Good afternoon. My name is David Tarpley. I'm an attorney with the Legal Aid Society of Middle Tennessee and the Cumberlands, based here in Nashville. Today we're going to talk about home mortgages. What are they? How do they work? What kinds of problems do we regularly see with them? And what to do about it. First, let's talk about what a mortgage is. A mortgage is a paper that has in it an agreement that the homeowner enters into with a creditor that says that if the homeowner does not pay back whatever debt obligation that it has with the creditor, that the creditor has a lien on the home and that the home can be sold to pay the debt. Now in Tennessee, unlike many states, the creditor does not ordinarily have to go to court to enforce that lien. The creditor can do it under what are called power of sale provisions that are in our law, in the statutes, and are also contained in the mortgage instrument. In Tennessee's version of a mortgage, we call a deed of trust. You may have seen in the closing papers on your loan or your purchase a paper called deed of trust. Well, that is your mortgage, Tennessee's version of a mortgage. And what it says in effect is that the creditor that you owe money to, it may be the company that loaned the money originally, or it may be another company that the loan has been sold to. The creditor can enforce that loan against you by having the trustee that has to be appointed for that purpose sell the home through auction after public notice has been given and you have been given notice. Mortgage accounts may or don't always include an escrow provision. When you make your monthly payment on a mortgage, it always consists of two parts. The principal, which is the part of the original loan that you're paying back in that payment, and the interest that is accrued on that principal since the last payment, or if it's the very first payment, then since the loan was first made. You always pay principal and interest with every mortgage. The majority of home mortgages, although not all, include what's called an escrow provision, and that means that in addition to paying interest and principal, you are paying an additional monthly amount that your mortgage company, we call that the mortgage servicer, is setting aside to pay your property taxes and excuse me, your homeowner's insurance as they come due. Of course, property taxes are always due yearly. Homeowner's insurance may be due yearly or semi-annually, or more often if you're paying it yourself. But your mortgage payment may consist of just principal and interest if you're handling your own homeowner's insurance and property tax. Otherwise, it includes all of those features. We talked about the servicer. Let's talk about who the different parties are in every mortgage transaction. First, of course, is you or me. That's the borrower. We're the ones that buy the house and owe the money. Then there's the lender, that is the original creditor. And, of course, very often that loan is sold. Sometimes it's sold right after it's been closed to another company, which becomes then the holder or investor, the owner of the loan. Then there's the servicer, and that's the company we commonly think of as our mortgage company, which is the company we deal with week in, week out, year in, year out, until it's transferred. And that's the company that sends us our monthly statements, that we send our payments to, that pays our escrow items if we are escrowing money for that, that supposedly, hopefully, keeps our loan record straight and accurate so that at any time it can tell us what we owe and when our last payment was and anything we need to know. That party is the servicer. But actually, the majority of home loans in this country are not owned by the same company that does the servicing. Mortgage loan servicing is a huge and very profitable industry. And mortgage servicing is traded around the country thousands of times a week. And big blocks of mortgages, your and mine and maybe 2,000 or 3,000 others, are sent in big packages to some other company to service. And of course, they charge a fee for doing that servicing. We always have a right to know, regardless of who our servicer is, the company we're actually dealing with, we always have a right to know who the actual owner or investor of our loan is. And we can find that out by sending a written request to the servicer for that information. They must provide it if we request it. There are a variety of different types of loans that we can take. Usually, these days especially, usually the loans that we take are simply straight payment loans with a certain beginning and a certain end, maybe a 30-year loan, or maybe a 20-year loan, or maybe a 25, or maybe even less term if we can afford it. Generally speaking, for any given situation, the shorter a term we can take, that is, the shorter the agreed time to pay our loan, the lower the interest rate that we will be charged. So if we're taking a loan that where we would qualify for, say, a 20-year loan, we can get a better rate on that 20-year loan than if we take a 30-year loan for the same amount of money against the same home on the same date. Now, there are loans which are so-called variable rate loans, and that is loans where by the agreement we sign, that is the promissory note that we sign, the rate changes over time. These are not as common as they used to be, but they're still out there. And if you enter into a variable rate transaction, the rate will stay at a certain amount, the certain rate, for a given period of time, typically either 2 or 3 years. But then it will change, and of course the change is usually to go up. Now, occasionally in a falling market we see rates come down, but usually they go up, at least initially. So if you do a variable rate loan, expect the rate to rise at least once or twice. It may or may not level off after that, but you should never do a variable rate loan unless you feel you can meet a worst case scenario in terms of that rate going up over the next several years, just depending on what the market bears. There are loans with a balloon payment. What is a balloon payment? A balloon payment is where the loan pays out like most loans for a given period of time, and then all of a sudden the entire balance is due. These again are not as common as they used to be, but they're still out there. And these are loans in which, say, for 5 years you might make a mortgage payment of $600 a month. And then when that 61st payment becomes due, all of a sudden the payment is the full outstanding balance on your loan of, say, $60,000. And of course your only option there is to refinance, either with that same lender or with some other lender if necessary. Again, another variant is the so-called interest-only loan, where for some limited period of time you pay only the interest that accrues each month, but you don't pay anything on the principal. Well, of course, the attraction of that is, in the short term, that your monthly payment is less because you're not paying any of the principal back. You're just paying interest. The disadvantage is that those are always for some fixed period of time, and then after that, it just depends upon what the agreement calls for. And this can be quite a trap. This is a true story. Just last week, I was talking with a professional man who had just discovered that a second mortgage that he had taken out 10 years ago was interest only for 10 years. And then all of a sudden, after the 10 years, the loan called for him to start paying principal at such a rate that within 5 years he would pay off the loan entirely. And in his case, it meant that his payments went from about $900 a month all of a sudden to $4,000 a month. And he didn't know how he was going to handle that. And again, this is a well-educated professional man who discovered after 10 years that his loan was set up that way. And the way he discovered it was all of a sudden he got a statement calling for a $4,000 payment instead of a $900 payment. So don't assume that it's just folks who, are unsophisticated or not very well educated who can be trapped in these things. Anybody can be. All right. Let's talk about protections that the law gives you or tries to give you in entering into a mortgage loan. In the first place, under federal law, in many states true as well, but regardless of the state law, federal law gives us all the right to advance written notice setting out the cost and terms of a mortgage loan that we're going to enter into prior to the date that we close the loan. And again, on the day that we go to close the loan, we're entitled to get those terms in writing again, regardless of what is explained to us orally. We're entitled to 2 shots of those credit terms and costs in writing, once in advance of the closing and again when we do the closing. And if there's one piece of advice that everybody should follow when they're closing a mortgage loan, that is sitting down to sign and obligate themselves, they should never sign until they have a full understanding of what they are obligating themselves to pay, both over the long term and monthly in the short term. They should not have any questions left in their mind about what their obligation is. And any questions they have about the loan should be answered by the person who is helping them do the closing. If the person who is sitting down to do the closing with you can answer your questions or dodges the questions or cannot explain to you fully what the credit terms are, you should not close. Certainly nobody makes you close, and you should not close. Similarly, you should never, ever rely upon any verbal assurances that the closing agent gives you about what's going to happen in the future concerning that loan. If you're told that after 6 months or a year or whatever, you will be allowed to refinance, don't believe it, because that agent can't tell you that for sure, and nobody else can. That can depend on many things that haven't yet happened in the future, including the market change. So don't rely upon any verbal assurance that you'll be able to refinance at a lower rate, or that your payment will go down, or that anything else will happen in the future. If they say something's going to happen in the future, make sure it's in writing, it's very clear, and nothing is left to chance. But on the whole, if something is going to happen in the future, it's set out in the terms of that promissory note that you sign and in that disclosure statement, that Federal Truth in Lending disclosure statement that lays out all the costs and terms of your loan. Don't listen to anything that's not in those papers about what is going to happen to your mortgage loan, because it's probably not true. Now, there are certain types of mortgage loans that debtors have a right to cancel within 3 business days, and I'm going to tell you what these are. Well, first I'll tell you what they're not. You do not have the right to cancel a purchase money loan. That is when you were purchasing your home. Once you sign those papers, that's it. You are obligated. But if you are taking a loan against a home you already own and live in, and maybe it's a refinance of a mortgage you already have, you're getting cash out, you're getting a better rate. Maybe it's an agreement for home improvements and you're financing that with a mortgage. Maybe it's a free and clear house. You don't owe anything on it, but you badly need money to do something or other, and you decide you can afford to borrow money and put a mortgage on it. Those are the situations in which you have, under federal law, a right to cancel that loan within 3 business days after you sign the closing papers. You do not have to have a reason. You don't have to offer any reason. All you have to do is to give written notice, and it must be written notice. Verbal notice doesn't count. Written notice of your decision to cancel a loan. And the loan papers you receive at closing must give you some forms that tell you exactly where you need to send that notice or deliver it if it's local. And all you have to do is sign and date the form and send it back. That does it for you. And you're out of it. You have no obligation. If you've already paid some money in the transaction, you have the right to get the money back. There is no transaction at that point. Nothing can happen to your credit to hurt it. It's done. You're out. And if you decide within 3 business days that you made a mistake in closing that loan, by all means, you should cancel it and get out of it. Don't stay in it and risk a foreclosure later. Well, let's talk about when troubles begin with mortgage payments. And troubles begin with mortgage payments for all kinds of reasons. They happen to all of us. Another baby comes along in the family. Someone loses a job, layoff, illness, company closes down. Somebody is forced to retire and go on disability. Divorce, family breakup. All the different things that happen to folks that cause their disposable income to go down and impair their ability to pay their mortgage. I guess the best way to start this discussion is to say that the best advice is the advice that a cancer patient would receive, and that is the earlier you seek professional intervention, the better. The more likely you are to have a successful outcome both with cancer treatment and with trying to fix a mortgage problem. The worst thing that we see that people have done is to ignore a mortgage problem, especially once they're in default and can't pay. Sometimes they sort of tend to think maybe the problem will go away if they just ignore it. Well, it doesn't, of course, go away. It just gets worse. The worst thing you can do with a mortgage company is ignore it. If you are not paying and you are not talking to it and trying to get something worked out, then you are headed for foreclosure and eventually homelessness. What you need to do, preferably before you actually get behind, is to try to open a dialogue with your mortgage servicer about what has happened to you, why you can no longer pay the amount that your mortgage calls for, and what relief can they give you. There are a variety of things they can help you with, and we're going to talk about what those are in a minute. But in some cases, folks find that they have trouble talking to their mortgage servicer. I imagine we've all spent time on the phone trying to get through to the phone numbers where we're supposed to call for customer assistance. Good luck with that. We can spend 30 minutes or an hour on the phone and never get to anybody, or we get to somebody and we talk to them one day, and then 2 days later we hear a whole different thing from somebody else in the company. We've all been there if we've tried to work out things with mortgage servicers. The best thing I can say is if you simply cannot get anywhere with your mortgage servicer, if you can't make any sense of them or you can't get any effective communication going, seek the assistance of a qualified housing counselor. They do know how to get through. Not only will they advise you as to what your options are, but in nearly every case they can get some dialogue going with the mortgage servicer. This industry is infamous for its lack of effective means of dealing with its own clients. That's us, the homeowners. Okay, now let's talk about the types of help that are commonly available for folks who are having trouble with their mortgages. First, there's the modification that we've heard so much about in recent years. Now, what a modification is a permanent alteration of the terms of your mortgage. Now, it's not temporary, it is permanent. There are various types of loan modifications. There's been a lot in print recently and in the news about what are called the HAMP modifications, and that's HAMP. HAMP is the acronym for Home Affordable Modification Program. This is a program that was set up through the federal government in 2009 to help homeowners who hadn't lost all income but could no longer pay the full regular mortgage payment. Now, it is not binding on any servicer. No modification is binding, and you need to understand this. A modification is not something that any court can make a servicer do. Servicers do work modifications where they find that homeowners qualify. And if the owners of the loans, the investors' guidelines, permit the servicers to do that. Because remember, that owner or investor in the background, which is probably a big company you've never heard of, has an agreement with that servicer that sets out the limits of what that servicer can do to help you if you are behind. But that said, the HAMP modification, which was set up through guidelines issued by the U.S. Treasury Department in 2009, are voluntary with the servicers, but they do provide for many people an effective loan modification. Now, it may not be a HAMP modification. It may be what is called a traditional or proprietary modification that's simply offered by that particular loan servicer. But whichever kind of modification it is, there are certain things that are true of all modifications. The first is that there is a written agreement that sets out all the terms of the modification. There's no such thing as a verbal modification. I've had a few folks say to me, "Oh, well, they told me that my loan was modified." And I'll say, "Well, what did you sign? Where's the paperwork?" "Oh, well, there wasn't any paperwork." Well, then it wasn't a modification. I don't know what it was, but it wasn't a modification, okay? It's always in writing, and there's always a detailed agreement about what the new terms of the loan will be. Second, every modification, if it's approved, begins with a trial payment period of 3 months. The servicer says, "Okay, we are willing to put you on a modification provided that you meet the provisions of a 3-month trial period." And they tell you how much the payments are going to be for that 3-month trial period. It is essential that all of those 3 payments be made absolutely on time and in the right amount. No excuses given. There's no such thing as, "Oh, can I make one of my 3 trial period payments late?" No, you cannot. If you cannot make those 3 payments right on time in the right amount, it is over. And there's nothing anybody can do to change that. So those first 3 trial period payments must be made absolutely on time. Now, before you make those 3 trial period payments, you have to sign something saying, "Yes, I'm going to make those payments." And it has to be gotten back within the time limit that the servicer says we got to have that back. Okay, well, once you've made your 3 trial period payments, now comes your package for the permanent modification. You have to sign that and get it back within the time they say. Now, here's what the modification will do. There's good and bad. Let's take the bad first, but it's unavoidable. Whatever you owed in back money at that time, however much you were behind on, we call that the arrearage. The arrearage is what we call capitalized. That means it's added to your loan balance at that time. So, for example, if your loan balance was $50,000, but you were behind $10,000. They will add the $10,000 arrearage to the $50,000, and your new loan balance is $60,000. The good part is that your rate is modified, nearly always down, so that even though you usually start with a higher new principal, you are starting with a lower rate. The objective being, if possible, to get your payment down because you are being charged a lower interest rate for the rest of the loan term. As I said, there are time limits for getting paperwork back to the servicer. Don't delay. Don't ask them for extensions, because even if they say okay, it may not be okay, believe me. You just need to stay on the ball and do everything within the time limits that the servicer says. Now, one very common problem is that servicers have dragged their feet, sometimes for many, many months, on processing loan modifications. And this is particularly true in HAMP modifications, for whatever reason. And after a while, all that information that they've gotten from you for your loan modification becomes stale. Generally speaking, if it's 60 or even 30 days old and they haven't yet processed your application, they call it too old. And they say, oh, we got to have it over again. We've seen clients who have had to send the same information 5 or 6 times while they are waiting to hear on a loan modification. One problem that frequently comes up is, well, what about payments during that period of time? Sometimes the servicer has already stopped accepting payments because they say, well, you're behind. We're not going to accept partial payments. We're processing your mod application, but we don't want your monthly payments because you're behind. What should you do with your money? What you should not do with your money is spend it on something else. If the servicer is not accepting your payments, but it's still kind of in limbo about what's going to happen to your mortgage, save that money. Save it up. Don't spend it. Put it in an account. Leave it there. If you're working with an attorney at that point, ask the attorney to escrow it in the attorney's escrow account, because that money can do you no harm and will probably do you some good in working out that mortgage problem down the line. Well, we've talked about the modification. Now let's talk about the forbearance. The forbearance is a different type of mortgage relief that the servicer can give you. The forbearance is a situation where for a limited period of time, a certain number of months, they forgive all payment, but then later on you have to make it up. Now, one possible way to make it up is they might be willing to extend out the end of the term and let you pay it on a longer term. More likely, what they're going to do is come along and say, well, you're not making any payment for, say, 4 months. But after that, we're going to require payments of a much higher amount for several months until you've made up that back money. That type of forbearance usually isn't very helpful, because even though it gives you relief for those few months, it just digs a deeper hole once you have to pay back those extra big payments after that. Another type of relief is the so-called deed in lieu of foreclosure. Now, a deed in lieu of foreclosure is one in which you're facing the probability of foreclosure. There doesn't seem to be a way out. A modification is not feasible. You can't do a Chapter 13 bankruptcy because you haven't got the income to fund a Chapter 13 plan, but you don't want to actually be foreclosed on. So what you do is you talk to the servicer about deeding the property to the servicer instead of the servicer foreclosing. And some people really want to do this just to avoid having that foreclosure put on their credit reports. Now, the deed in lieu is not possible unless the mortgage is what we call underwater. Now, what that means is that you owe more money on the mortgage than your home is worth. And unfortunately, that's all too common these days. As the mortgage market fell over the last several years, so did the value of homes. It's getting better, a little better, very slowly now over the past year, but there are still many, many thousands of folks who find themselves in a situation where they can't even sell their homes because they owe more on them than they're worth, and nobody's going to buy them because they'd be buying the obligation to pay a mortgage that's more than the property's worth. And in that situation, sometimes lenders will do a deed in lieu of foreclosure just to let you out. They don't have to go through the expense of foreclosure, and the property is deeded to the lender. Another type of relief sometimes available is what's called the short sale. The short sale is another device which can sometimes work where the property is underwater. That is, more is owed on it than the house is worth. And in this situation, you actually go out and hire a real estate agent to try to find a buyer on a short sale. The agent helps you find a buyer. You enter into a regular contract for sale, but extra agreements as well, providing that the sale is conditioned upon your mortgage servicer approving a short sale. And the way that works is, and we'll give an example. Let's say that you owe $120,000 on your mortgage. You're facing the foreclosure soon, but your servicer agrees that if you can find a qualified buyer who will buy the property for this sum of, say, $100,000, the servicer will accept that $100,000 in full satisfaction of the debt, even though they're not getting everything that's owed. They will allow you to sell the property to that buyer under that contract. They will accept the $100,000, and you are clear of the debt. There'll be no foreclosure. Again, the short sale, like the deed in lieu, will only work where you owe more on the property than the value of the property at that time. Those are the common methods that people use to try to avoid foreclosure other than bankruptcy, and that is the modification, the forbearance, the deed in lieu of foreclosure, and the short sale. We mentioned bankruptcy relief. Chapter 13 is very useful for folks who have had a problem with their mortgage. Maybe there was a layoff and they lost their job for a while, but now they're back at work, maybe even with a higher income. Something happened that really disrupted the household income flow, but they're getting on top of it now. So even though they ran up an arrearage on their mortgage and it's close to foreclosure, if they're just given a chance, they can not only put their mortgage payments back on track, but in a period not exceeding 5 years, they can get caught up, get the arrearage paid as well. Those folks qualify probably for a Chapter 13 payment plan, where through protection of the bankruptcy court, they can reinstate their loan and get their arrearage paid, although the court cannot give them more than 5 years to do that. Again, the bankruptcy is something that can be done almost at the last minute if necessary, as long as the servicer of the loan is notified of the bankruptcy filing by whatever means any time prior to the sale. The servicer must stop the sale. No ifs, buts, arguments, it must be stopped. And then, of course, everything after that happens through the bankruptcy court, and there will not be a sale unless the bankruptcy court approves it, and the bankruptcy court's not going to approve it if you and your bankruptcy lawyer can show that you meet the requirements for a Chapter 13 plan. A lot of bankruptcy attorneys advertise heavily that they do these. There are a lot of practitioners out there who do this, and of course there are downsides to any bankruptcy. Folks who haven't done it before especially would like to avoid it if possible. But for a great many folks for which nothing else will work, it is the last-ditch effective resort to stop a foreclosure. again, if I can leave you with one thing that you should retain from this session, it is this. When you first see that you're going to have a serious problem with your mortgage, get advice quickly. Start a dialogue with your mortgage servicer quickly. Excuse me. Don't let it go, because like with cancer, the longer you let it go, the worse it's going to get. Thank you and good day.